Welcome everybody to another I can't believe this type of stuff happens episode of Lockdown 23 in 1. That's right, today we're going to be speaking on an individual by the name of Bradley Yawn. He'll be going in front of the judge to get sentenced today for carjacking, kidnapping, and sexual assault of a 77-year-old woman. The woman lived to tell her story but died shortly after. Very sad situation. I'm not going to get into all the details of the case. Like I said, today we're just going to witness the sentencing. So with that being said, let's jump right into it. If you enjoy all things lockup and crime related, then this is absolutely where you need to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today.
John, you have the right to make a statement directly to the court telling me anything that you think I should know before I sentence you. Your statement in allocution is voluntary. You do not have to make a statement, but if you would like to make a statement, now would be the time to do so.
Your Honor, people in the stands, I did not hurt your mother, your grandmother. I did not do any of that. I wasn't part of that this night. I was not there. There's a lot more to this than y'all know. Your Honor, I'm not guilty for this at all.
Like I said, I'm not going to get into the details, but there's so much evidence against this guy, it's unreal. And for him to say that, look the family in their eyes and say it, dude's a straight monster.
The court has considered the pre-sentence investigation reports, the evidence presented at trial, the statement by Mr. Yawn, the arguments of counsel, as well as the statements and victim impact statements given today by family members. All of the statutory and non-statutory factors in aggravation and mitigation, whether specifically mentioned or not, the history and character of the defendant, and having due regard for the seriousness of the offense and with the objective of restoring the defendant to useful citizenship, I find the following. As to factors in aggravation, certainly the conduct caused or threatened serious harm. The defendant did receive compensation in taking the items from the person, vehicle, and home of his victim. The defendant has an extensive history of prior delinquency and criminal activity, including not less than 12 misdemeanors, but more importantly, sentences to the various departments of corrections in Illinois and Missouri, including 3 years, 3 years, 3 years, 5 years, 4 years, 3 years, 3 years, and 7 years. None of which curtailed Mr. Yawn from committing these offenses.
Look, I'm not a mathematician. I'll add it up when I edit it, but if I were to guess, that's like close to 30 years in prison he's already done in 2 different states. Man, this guy's a menace. And I can tell you almost for a fact, just by the judge's voice, that smoke is gonna be thick.
The court finds that a sentence is necessary to deter others from committing the same crimes. Specifically finds the victim to have been 65 or 60 years or older, being 76, 77 years of age. I also note that according to the PSI, Mr. Yawn was on a pretrial release for a felony in St. Charles County, Missouri, 2111-CR-03413, an unlawful possession of firearm by a dangerous felon, a Class C felony in Missouri. Also Marion County, Missouri, 21 MR-CR-00188 for a charged second-degree burglary, which would be a Class 4 felony in Missouri.
So the judge said he was on some kind of pre-trial release when all this stuff happened. They had the power to keep him in jail and all this could have been avoided. But then again, this ain't Minority Report. Not even Tom Cruise could have seen this coming. I just like to put myself in everybody's shoes, look at it from different angles.
In reviewing the factors in mitigation, I am in agreement with the state's position. I find none that apply to Mr. Yon. And again, the court is to consider the character of the offender. Mr. Yon, in my practice of law and in all my years, you are the most reprehensible person I've had in court before me, as public defender, as state's attorney, and now as judge. You take no responsibility for crimes that you clearly committed and were proven beyond a reasonable doubt. I believe you're narcissistic and unable to appreciate that, because to admit that would be admitting a fault, and in your mind, you are perfect. Well, sir, you're going to be perfect for 130 years in prison, because I'm adopting the state's recommendation.
Welcome to Sizzlers, ladies and gentlemen.
Invasion for using a dangerous weapon during such. The maximum 30 years is imposed. I'm also finding that that crime resulted in great bodily harm to the victim, meaning you'll serve it at 85%, not 50%. That'll be followed by 18 months mandatory supervised release if you're ever released. Count 3.
130
Aggravated
blickums.
kidnapping, Class X felony. I'm imposing the maximum 30 years. Department of Corrections. That likewise will be at 85% for the same reason as previously stated, inflicting severe bodily injury. That will be consecutive to the sentence in count 1. Count 4, aggravated vehicular hijacking. Class X felony, 6 to 30 years. I'm imposing a 30-year sentence maximum, followed by 18 months mandatory supervised release, specifically finding that that should be served at 85%, again, because your actions resulted in great bodily harm to the victim.
Christine Lohman even says she wasn't hijacked
Sir, I
herself
would not speak.
in the video.
So that will be consecutive to counts 1 and 3. Count 5, maximum on the Class X aggravated criminal sexual assault. Range 16 to 40 years. I'm imposing the 40-year sentence. That will be followed by mandatory supervised release of 3 years to life, and that by statute will be mandatorily consecutive to the sentences imposed in counts 1, 3, and 4.
So much smoke, man. I don't know how he's even sitting up still.
Those should total the 130 years being imposed.
Is that the gavel?
By statute, I must advise that at 85%, you'll be serving a total minimum of 110 years in the Illinois Department of Corrections. Anything else regarding sentencing, Mr. Jones, prior to advising of appeal rights?
No, Your Honor.
Mr. Nelson?
No.
Mr. Yon, you do have the right to appeal. If you only want to appeal the judgment of conviction, not including the correctness of the sentence imposed or any aspect of the sentencing hearing, then within 30 days of today's date, you must file with the Circuit Clerk of Adams County a written notice of appeal, or request that the Circuit Clerk prepare and file it on your behalf. However, if any part of what you want to appeal relates to the correctness of your sentence or any aspect of the sentencing hearing, then before you file a notice of appeal, you must file first, within 30 days of today's date, a written motion to reconsider sentence and/or challenging sentencing hearing. That likewise would be filed at the Adams County Circuit Clerk's office. Your motion must be in writing, must be filed with the Circuit Clerk of this court within 30 days of today, and must include all of the grounds or reasons for your motion, as any issue or claim of error or mistake not included would be waived for purposes of your appeal. If your motion is granted, the sentence may be modified or some other action may be taken to correct whatever the problem may be. If your motion is denied, okay.
Give her some water. Tap. There you go. Henceforth, Your Honor.
Okay, okay. You good? All right. If your motion is denied, then you would have 30 days from the date the motion was denied to file with the circuit clerk of the court a written notice of appeal, or to request that the circuit clerk prepare and file it on your behalf to start the process of going to the appellate court. If you cannot afford the assistance of an attorney for your motion or your appeal, an attorney will be appointed to represent you free of charge. If you cannot afford copies of the transcripts in your case for your motion or appeal, those likewise will be provided to you free of charge. Do you understand your right to appeal, Mr. Yan?
Yes, sir.
All right, we will be in recess.
Your Honor, I have some things to take up with regards to the transcripts. I'm still waiting on pretrial transcripts that you said would come a long time ago.
Mr. Yan, you're represented by counsel, and so he'll need to make all motions and arguments to the court if he chooses to do so.
Okay, as far as appeal, I'll represent myself on appeal at this time, so I'm going to need the transcripts. I mean, unless they're being manipulated like the last ones were, and they need time to do that.
Mr. Yan, again, you're being represented by counsel at this time, and so he'll have to make all motions and arguments for you.
I need the transcripts. It should have come a long time ago. This year's transcripts.
Mr. Jones, do we want to take up the 20...
His lawyer don't give a damn about his transcript request, but you could tell he ain't vibing with him, man. Gotta be court appointed if I were to guess. At least his tie's made.
F 713 and 720.
Let's see if he asks for the transcripts.
Today, I'll have an order prepared showing those cases are dismissed.
All right. I'm sorry, we're going to have to go back on the record also. Thank you for reminding me of that. Mr. Yan, because 22 CF 671, you were sentenced to 7 years while you were awaiting trial in this matter, these sentences are also going to be consecutive to that sentence. So that'll be a total of 137 you'll be serving.
The 671, the one where y'all violated my rights?
That's enough.
I'm asking a question.
I don't need him back for any order of habeas corpus. All right. So when you got the orders drafted?
Yes, the orders are drafted, and we're providing those to Mr. Nelson.
Man. Her hair is white as the driven snow, ain't it? Blinded me a bit.
I need the transcripts.
He's still asking for the transcripts. Lawyer ain't asked for none of it yet. He's just ignoring them. Completely ignoring them. Look at the stitching of his coat. This guy's built like that. Is it Teflon? Public defender? I don't know. He's gotta be pro bono. Or the best public defender around. Jeez, look at the trim in that jank there, man. That'd pick up any lady around town. You still ain't getting them transcripts. I like this guy.
723 miscuts.
Yan, on state's motion, 21 CF 713, 21 CF 723 are being dismissed. That order also will be provided to you. Anything else, Mr. Jones?
Nothing from the people on this case, Your Honor.
Mr. Nelson,
Nothing, thank you.
we adjourned in this case.
Ladies and gentlemen, please rise.
John, I think we need him for the next case.
Yes, there's another case.
We have another
with
case
Judge
with him.
McCarthy.
How dare you wink at us,
Pick that up.
you scumbag. Well, there you have it, ladies and gentlemen, 137 years for a narcissistic career criminal. That guy, if you were to ask me, I'm probably be covering a story in the next 10 years or less of him getting killed in prison if I were to bet it. Ain't no way they're gonna keep a guy like that in no PC block for 137 years. Might be for like the first 5 or 10, maybe, I don't know. But when he gets out, I guarantee someone's gonna get him. Anyways, I'm out of here. Stay tuned. I got plenty more content coming your way. In the meantime, though, tap that like, subscribe, notification bell if you enjoy. And as always, y'all be easy, be safe, and more importantly than anything, stay free.